Good morning. Before we get started, I just want to convey thanks on behalf of the court for counsel on both sides for your willingness and interest in appearing in person before the court today during these admittedly challenging times. We have one case on our docket this morning, so we'll go ahead and now call case 2050736, Rollins versus Home Depot. Mr. Allison, we'll hear from you first.
Your Honor, Aaron Allison for Mr. Kevin Rollins.
Yes, please. Thank you.
May it please the court, Your Honor. Slight inadvertence and excusable neglect, manifest injustice. These are terms which are key to the appellant's case and argument before this most honorable court. A brief timeline of facts, and facts are intensely important to the appellant's case. February 8th, 2019, Mr. Kevin Rollins filed suit in the state courts in Texas claiming a personal injury regarding a non-subscriber work-related injury case. March 15th, 2019, the case was remanded to the federal court on complete diversity of citizenship between the parties. On May 5th, 2020, the defendant's motion for summary judgment was filed with the trial court for the Western District of Texas. On May 27th, 2020, that motion for summary judgment was granted by the trial court. On June 3rd, 2020, the plaintiff first received any notice that the motion for summary judgment existed, had been filed, and an order had been granted upon it. This occurred in a phone conversation between plaintiff's counsel and defense counsel, who were engaged in negotiation settlements on the case and had been engaged in negotiation settlements on the case for some months. That was the first moment that plaintiff's attorney realized and had any knowledge whatsoever of what had occurred.
But counsel, let me just stop you there if I could. It's not the first notice that the plaintiff had, correct? Because the email had been delivered. There's no dispute about that.
There is no dispute about the email notification. The plaintiff's attorney's email was on file and correct with the federal court. The notice and a copy, we think, of the motion for summary judgment, which was filed by the defendants on May 7th, 2020, went into a separate portion of the email accounts. Prior to that date, all filings from the federal court and the state courts came into what is called the general mailbox. It is general@AaronAllisonLawFirm.com. That email is up during all business hours. It's checked continuously by two paralegals and the practicing attorney throughout the day. And all emails are physically copied and put in the trial lawyer's box for his physical review.
Bottom line is you gave the court the email address that we should be using for ECF?
Absolutely.
Okay, and the clerk's office did use that email address here?
The courts did.
It's just that for reasons internal to your firm, you did not see it?
Did not see it because the notice of motion for summary judgment filing and even the order after came into a different section of the email called Other.
I don't doubt your sincerity that, and I certainly have no reason to doubt your sincerity that you did not personally see the email, but why should that matter from the standpoint of efficient judicial administration and the text of our rules?
It matters because of the fact that all previous emails and all subsequent emails came into the place they should have come into. These two emails from the court, the motion for summary judgment and the order from the judge granting it, went into Other. And are
you suggesting there was an error by the clerk's office, or was the error on your side? Not you personally, but your firm.
We had no prior knowledge and no actual or constructive knowledge that our email system was not functioning properly prior to and after. This is a strange event, and we don't know the reason why those two filings from the federal court went into this other email box, which was not monitored, called Other, and they could not be opened when they were discovered.
What about our Trevino case?
The Trevino case, and in differentiating my case from the Trevino case, my understanding is that they had virus software And they did have some notice or prior notice or understanding that it was causing a problem with their email system and receiving documents or things in their email. And they had conscious knowledge or actual or constructive knowledge that there may be a problem receiving notices or filings in their email system. In my case, we had absolutely no actual knowledge or constructive knowledge that this filing would go into the other box. And subsequent filings went where they should have gone. Previous filings went exactly where they should have gone. This specific instance, the motion for summary judgment filing and the judge's order went into this other box, and they were unreadable. On June 3rd, when I conducted this phone communication with opposing counsel and was notified for the first time.
But counsel, so it may be Trevino that I'm thinking of, but one of our cases says that this is sort of the 21st century equivalent of the dog ate my homework excuse. And another thing that Trevino said is that counsel has a duty to diligently look after the status of the file. In other words, you need to monitor the docket. Now, so there was also a case management order here, correct?
Correct.
And the case management order specified a dispositive motions deadline, correct?
Correct.
If I'm right, the case management order also said that responses to motions, including dispositives, needed to be filed within 14 days of the date of filing, correct?
Correct.
Did anybody at your firm ever check the docket on May 11th, I think was the operative date for dispositive motions, or around that time to see if a dispositive motion had been filed?
No. And here's the excuse to that. When we have a docket control order and we lay out our deadlines for dispositive motions or other duties that are required prior to trial, if I receive a motion for summary judgment or any dispositive motion or any other document from the other side, the first thing I do is go to the trial notebook where the docket control order is kept and immediately check to make sure that their filing was timely pursuant to the docket control order. That's what I would have done if I'd had physically received and been able to address this motion for summary judgment.
But don't you read Trevino to require that in addition to making sure the other side's filings are timely, you have a duty to make sure that the other side made a filing at all in accordance with those deadlines?
No, I disagree with that duty. I don't think that a practitioner has the duty to check to see on May 11th or May 12th, did they file a dispositive motion? I think that the duty arises when the practitioner receives the filing from opposing counsel. At that moment, he goes back and checks the docket control order. If he has a duty to check the docket control order the day after or subsequent to that deadline and go back to the courts and say, has anything filed, has anything been filed?
Well,
I think that's an undue burden on the practitioner.
Let me be more precise. I'll read from Trevino what it says. Plaintiffs had a duty of diligence to inquire about the status of their case. How's that not foreclose your relief here?
Had a duty to inquire about the status of their case. If the court's finding that if a lawyer has a duty to go back and check his docket control order and then approach the courts to ensure that nothing has been filed, well, then that would be a new standard that I haven't seen before, a procedural standard that the court would be creating in this case. I think that that's an undue burden on the practitioner. As practitioners of law, we react upon filings that we receive and react off of that. If I received a motion for summary judgment, I would have gone back and checked.
But just to be clear, you did receive it at the location. You may personally not have read it, but this is no different from any sort of mailbox rule. As I understand basic procedure, once it hits your mailbox, the law doesn't see if you actually opened the envelope and read it.
Right, and if it had actually hit the email box and then I had failed to even open it and look at it, okay, well then there'd be some credibility to that. But it went to a different part of our email address, which no other filing had gone to before or since. And when it was discovered on June 3rd, it was unopened.
Hold on, you said a different part of the email address. I just want to make sure. The clerk's office did use the same email address.
They did.
Okay. It's just
and
that
my system shifted it.
It's something internal to your system. Again, I don't doubt your credibility.
And an internal problem that we had no prior knowledge of, and through due diligence and examination have not been able to discover why it occurred. We do know that the moment I got the phone call on June 3rd and found out what had happened, I immediately rushed into the paralegal's office, pulled up the email, and did an analysis.
Right.
And then we saw it in this other box, and I said, open it and print it. It couldn't be opened and printed. So I communicated to the defense counsel, please send me a courtesy copy of the pleading. Then I contacted the clerk and said, please resend me the order so I can open it and so I can look at this.
I wasn't in private practice all that long ago. I can imagine that was not a good day for you, and I totally sympathize. I do want to make clear, because I think you've got 5 minutes left. I understand you have another argument. One argument is relief because of failed notice. You've got another argument, relief because summary judgment was wrong on the merits.
Correct. In our 59E motion, which we filed with the trial court judge, we gave a complete explanation of the facts that I've communicated to this court. And the judge...
But did you preserve the second argument, that summary judgment was wrong on the merits?
Yes, in that there's an issue in this case which is confusing, in that the trial court judge, when he received my 59E motion, waited 60-plus days to render his order denying it. We believe that he thought, in his mind, that the 59E motion should have my motion for summary judgment response attached to it. My understanding of the procedure is you can't, once an order's been given by a court, you can't then hand them a motion for summary judgment response. The door has been procedurally closed. You take your 59E or 60B reconsideration motion and slip it under the door to the judge. If the judge finds it and takes it well, then the door will be reopened, permitting you to provide the motion for summary judgment response at that time. And I think the trial court judge, in his mind, and it's a speculation based on the time it took him to render his decision on the 59E motion, was that he was waiting for plaintiff's counsel to send him motion for summary judgment response when the plaintiff attorney was precluded from providing that motion for summary judgment response because the order had been given, the door had been procedurally closed, and I think that it was an abuse of the judge's discretion in not granting reconsideration, not granting us the ability to then provide motion for summary judgment.
Okay, so I understand that you're explaining why you did not attach a summary judgment op. Did you, in the 59E motion, address the merits in any other way? Or was it just, I didn't get notice and judgment is wrong based on the lack of notice?
I didn't get notice and your judgment would be wrong based on this. Okay. Please open the door and provide me to provide my case.
Isn't your merits argument on appeal now forfeited?
I'm sorry, Your Honor?
Isn't your argument on appeal that it's also wrong on the merits? Isn't that forfeited if you didn't make that argument in your 59E motion in district court?
I don't think
we still have your argument about failed notice. That was absolutely preserved as far as I can tell. Okay, so you could, in theory, you can get relief based on lack of notice if that's a winning argument.
Right.
But this alternative argument, that summary judgment is also wrong on the merits, isn't that forfeited on appeal for lack of preservation in district court?
I don't think that it's forfeited, Your Honor, because the plaintiff's case and his case on the merits in response to motion for summary judgment, which as the court knows is a mini trial in and of itself, was never given the opportunity under the facts and circumstances to be heard, to provide his argument.
But counsel, isn't the point that if, I think that Judge Ho is also getting at also, if you had attached a proposed response to the motion for summary judgment or had put something of why the ruling on the merits was an error of fact or law, manifest error of fact or law, the district judge would have had the ability to consider that and rule on it.
Well, I mean, in our 59E motion to the judge, and I have to go back and read it again specifically, but I do believe that it would, I communicated to the judge that it would be manifestly unfair to deny the claimant the ability to provide his response to the motion for summary judgment, that reasonable minds would differ, that there was a genuine issue of material fact.
Actually, counsel, let me stop you there, because you just brought up something that you kind of started your argument with as well. This idea of excusable neglect and manifest injustice or unfairness, where is that in Rule 59E?
The statement of manifest injustice. I don't believe it is in my 59E motion, Your Honor.
Well, what Rule 59E says is that a motion to alter or amend a judgment must be filed no later than 28 days after the entry of judgment. It's very straightforward. It doesn't talk about manifest injustice, but I think our case law lays out one ground would be manifest error of law or fact, And if I recall your motion, you argued that it was a manifest error of fact, that
Correct.
the judge didn't realize that the plaintiff had notice of the motion, and that's what was argued, the manifest error of fact.
Correct.
Well, Trevino seems to foreclose that. It says that failure to file a response isn't a manifest error of fact. So, again, are you saying that excusable neglect or manifest injustice are concepts we should consider in weighing 59E relief?
Yes, I think that
Where is it in the rule?
to distinguish between my case and Trevino, I believe that the attorney in Trevino had some knowledge, had some prior knowledge, and either actual or constructive, should have known that he was having problems with that system, that they were having problems getting pleadings in. That would have initiated a duty on his part to really follow up and contact the courts and take the active action of calling the courts and double, triple checking what had been filed and what had been filed and when. In our case...
You reserve 5 minutes. You reserve 5 minutes for rebuttal.
Yes.
Thank you. Mr. Bell, we'll hear from you now.
May it please the court. Good morning. The fundamental flaw in appellant's argument is what this court has noted, and that is the idea that somehow I didn't receive notice. He did. As the court has noted, the ECF notice was sent to a registered user, Mr. Allison, at the account that he had registered with the court. There is no question about that. Apparently, it was sent to some other folder. Why? We don't know. Mr. Allison has said he doesn't know.
And I take it you don't question counsel's good faith?
No, not at all. No reason to. Not at all. But to analogize this situation, you talked about the mailbox rule. Suppose I'm filing a motion for summary judgment back in the old days, okay, and I mail it to the law firm of Smith & Jones, and Mr. Smith is the counsel that's on it, and their courier runner goes to the mailbox, picks up the mail, and puts my motion on Mr. Jones's desk. Same law firm, everything else. Was notice received? Well, yes, it was. Or if it was set on Mr. Smith's desk and he just didn't open it. Here, he got the email. There's no doubt about that. I mean, the undisputed facts of this case, and the important facts in this case are not controverted at all. A summary judgment, the scheduling order required MSJ to be filed by 5/11/20. A response was due in 14 days. Home Depot filed a motion on 5/7/20. It served it through the ECF system, as all other filings had been. Plaintiff's counsel was a registered user. The email was sent to his registered account. He got the email, and no response was filed within 14 days. And then when he filed his motion to alter or amend, as this court has noted, when he did so, he did not attach a response. And it's important because the judge, in the record, I believe on page 141, says he didn't file a response, but even beyond that, I've reviewed it, and it has merit, so I grant it. So how can he get beyond the idea of harmful error? He can't. So even if even the court doesn't want to reach the Rule 59 issues, any other argument has been waived. He addresses the merits of his argument in his appellate brief. But he never did it with the district court. So the district court never got an opportunity to review what his arguments were. Now, he could not file a motion in response. He could not file a response. He could attach it to his Rule 59 motion saying, Judge, if you grant me leave, if you cut me some slack, here's what I would say. And the judge could say, well, you know, in this case, I would. And that's why it's important to remember, as this court, I'm sure, is well aware, that the standard of review here is abuse of discretion. And this court held in the Banning case, 6F 3rd 350, a district court decision need only be reasonable. Well, based on these facts, the notice was properly sent to the account he had registered, he got the notice, didn't file a response, and the judge determined regardless that summary judgment was warranted. Is this court going to hold that that is an unreasonable position by the district judge? It doesn't seem, at least from my standpoint, that that's true. And this court, in the Coors case, 589F, 2nd 176, said appellate review of Rule 59 motions is quite limited quoting Wright and Miller on that. It's an extraordinary remedy. It's used sparingly. It can be used to correct manifest errors of law or fact. No one's claiming the judge got the law wrong here. All right? No argument there. It's all about whether he got the facts wrong, but the facts are undisputed here.
Well, counsel, so what of this idea of manifest injustice? I mean, if the plaintiff loses his case over this, I don't know if he has any other alternative remedy or if he got workers' compensation or if there's anything like that. But if he's totally foreclosed from the courthouse door because of this neglect by counsel, is that manifest injustice?
No.
And if it is manifest injustice, do we even get into that under Rule 59E? What's your position on that?
It's not manifest injustice. If it is, if the court ruled that, I would just say don't go to any conventions with district court judges. They're not going to be happy with you because every time a client attorney blows a deadline, he says, well, listen, it's manifest injustice to my client. So I filed it a week after the statute of limitations ran. Yeah, but it's manifest injustice to my client. No, it can't. Now, does the client have remedies? He does. They don't involve Home Depot, okay? But the client does have remedies. So it's not manifest injustice. Trevino is clear on this point. It really is that you cannot claim, okay, that the late filing of a response is manifest injustice if the late filing is within your reasonable control. Well, what were the things within counsel's reasonable control? The maintenance of his email system, okay? The monitoring of the other folder. He admits in his brief that it wasn't monitored regularly. Reviewing the court docket, all right? To see, as Trevino said, you have a duty to stay up to date on your case. And I understand we don't go around filing and looking every day, but I do a lot of appellate practice on the criminal side, a lot before this court. And there are times when I think, I got that record, I thought that record was done. I haven't heard anything from the court. Did I miss that? So I get on Pacer and look and see if I make sure I'm up to date. Now, do you do that regularly? Every day? Probably not. But when you're going to claim, the dog ate my homework, then you better have done more than just sit back and rely upon the fact that it was sent to the other folder as your argument. I think you have, if you want the extraordinary remedy to be applied, then you need to take extraordinary steps to make sure you're keeping up to date with your case. And that wasn't done here. I haven't found any great definition in case law of manifest error. Black's Law Dictionary, I think it's in my brief, describes it as plain and indisputable. That amounts to a complete disregard of the controlling law or credible evidence. For this court to reverse the judgment of the district court, it's going to have to find that the judge had a complete disregard of the controlling law. Well, based on Trevino, he was right on square with the controlling law, and he applied it correctly. Then we go back, finally, ultimately again, to the issue of preservation of error. Counsel didn't attach a proposed response. He never gave the trial court the opportunity to say, yeah, you blew it, but you do have a valid defense, so I'm going to cut you some slack. And perhaps if he had done that, then maybe the trial judge would have ruled differently. But the important thing on this, and the important thing to remember, is simply that the trial judge was the best one in position to determine what should go on here. And as long as he was consistent with the controlling law, which he was, and as long as he didn't just mess up the facts, which he didn't, then he didn't abuse his discretion, because his decision was what? It was reasonable, and this court shouldn't reverse that. Instead, this court should affirm the judgment of the district judge and affirm judgment in favor of Home Depot. Thank you.
Thank you. We have your argument. Mr. Allison, you've reserved 5 minutes for rebuttal.
Thank you, Your Honor. Your Honor, the appellee's argument would mean, if they're correct, would mean that under no circumstances, under no excuse, under any fact pattern that you can imagine, that when an attorney receives a notice, he's held to it. Whether or not that notice is defective doesn't matter. I think that's an undue burden, and that in and of itself is manifestly unjust
in
to
fairness,
destroy a case.
In fairness, I don't think that's his argument. Hold on. I don't think he's saying that defective notice is okay. I think what he's saying is the notice here was effective. It didn't actually reach you, but through no fault of the law. I take it just to make sure we're characterizing the argument fairly. If you disagree with that or think I'm mischaracterizing, please let us know.
I believe that the appellee relies on Trevino very heavily in the fact pattern that to promote his case, that in Trevino, the attorney had actual knowledge, or he had what would be deemed as constructive knowledge he should have known based on what was happening with his software system, virus software system, and knowledge that some pleadings or documents were not coming through, that he had a duty at that point to go back and check his docket control orders, contact the court, and he didn't. In our case, there was absolutely no actual knowledge, there was no constructive knowledge, there's absolutely nothing that would have communicated to us that there would have been a problem. We had been receiving...
I take your point that we should not extend Trevino to this case.
Correct.
So the discussion we're having here is whether we should or not.
Right.
Given the fact that notice was effective under the law, it just nevertheless did not reach you personally.
Correct.
That's the question presented.
Notice did occur pursuant to the law. It was sent to the appropriate email that was on file with the federal courts. An example, I'll give you an analogy. A postman knows my address, okay? He puts the letter that's addressed to me in my mailbox, but for some unbeknownst reason, that letter then shifts over to another mailbox. It's a mailbox that I have, but it's a mailbox which is never used. It's not designated for anything. And that letter, the notice, goes into that box. Was notice provided to the appropriate place by the court? Absolutely it was. Was the practitioner, the plaintiff, permitted the ability to have actual notice of it and react off of it as he absolutely would have if he had had? No. And not even the order from the court was received. It was filed to the right email address, but even the notice to the court of the order went into this other box and was unable to be opened. That's key. It wasn't that it went to the wrong box and then we opened it and could read it. My paralegal and me stood there and I said, open it. And she says, I can't. It's inoperable. It's unopened. That's why we went back to defense counsel and said, please send me a courtesy copy so we can read it. And then went back to the courts and said, please send me a copy of the order so we can read it, so we can formulate our motion for reconsideration. We had to have it. So I think that there should be, in very rare circumstances, which meet the facts of my case, the ability for the plaintiff not to have his case destroyed and thrown out, but the ability under those specific facts. I think it was an abuse of discretion by the trial court judge not to grant the 59E motion, then procedurally permit the plaintiff to provide him the motion for summary judgment response. My argument is that when the door is closed and order is given, I can't hand you the document. It can't be well taken. You have to procedurally open the door for me to bring you my motion for summary judgment response to then be reviewed. And we were never afforded that opportunity by the trial court judge. I think it was an abuse of discretion by the trial court judge under these specific facts and circumstances not to permit the claimant, the petitioner, to put in his motion for summary judgment response. He may have believed you have to attach it to the 59E, but there's no procedural rule of law that I know of which commands that or even suggests that.
Okay, but there was nothing preventing you from at least addressing the merits in the 59E motion itself.
I didn't have the belief that I couldn't address the merits of the case because I could not provide him my motion for summary judgment response, that I was precluded from doing that procedurally by his order. The mechanism to open the door back up would have been consideration on my 59E motion. This is the mistake. This is excusable neglect. This is a manifestly unjust. Under these facts and circumstances, please open the door and then permit me to put on my factual basis for my case and try to defeat the defendant's motion for summary judgment in the traditional way.
Thank you. We have your argument. The case is submitted, and I want to once again thank counsel on both sides for their interest and willingness to appear before us today. And with that, the court is adjourned.